All right, welcome back. So, several things on the burner here today. Yes, you heard the president there at the conference speaking about what needs to be done, how some of the steps he also intends taking. And incidentally, the 8-point agenda also included the rule of law. So we will come in at this point because the theme of that is NBA conference. We've got two gentlemen who are joining us to shed some light on that. Mr. Adebayo Joe, Senior Advocate of Nigeria, former Attorney General and Commissioner for Justice for your state. Good morning.
Good morning.
Then we also do have Afam Osigwe, also a Senior Advocate of Nigeria. Good morning to you as well.
Good morning.
Well, the conference, it's getting it right, charting the course for Nigeria's nation building. And the NBA says this was carefully thought out to reflect our current realities. So perhaps we'll start from that point, because this morning we woke up, came here with the news that a coup has gone on in Gabon, because they said that after the elections, it was contested, they were going to court, they didn't like how it was going on after 56 years. So some discontent there. It just goes to say, look, if people are not happy, something really needs to be done. So, Mr. Joe, from your perspective, having seen, I mean, in light of your theme, and the rule of law as well. We know this is important, but is there any chance whatsoever that a lot of the expectation we have about judiciary can materialize?
Yes. Okay, let me start from the rule of law. That is the bedrock of concerned democracy anywhere in the world. And judiciary is very key and critical in the implementation of the rule of law. Yes. You see, I, myself, speaking for myself, don't agree with most of the narrative being thrown out there as far as judiciary is concerned in Nigeria, because people tend to look at it from the negative perspective, that judges are being neglected, they are not being taken care of, or this or that. Which, from my own perspective, they are not true. They are not totally correct. Yes, we can do more, but painting or portraying that gloomy standpoint or position is not true.
That they're not well paid.
They are not well paid. No,
why do you say that?
I don't agree. Like we already said, I was Attorney General in your state between 2011 to 2015. Well, if I'm talking now, I'm talking from practical perspective, as opposed to most people who come and talk theoretically.
So give us a picture.
Yes.
Of what it was like.
You see, let me say this. If judges are not well paid, or if their conditions of such are too poor, as people are speculating, or as they are saying, there won't be any loss. Or once the vacancy is declared today, at any level, maybe at the High Court or at the Federal Court, Industrial Court, or calling for appointment of judges. If you look at the number of people, the applicants will be amazed. Will be amazed at the level at which lawyers are rushing to leave the bar for the bench.
What kind of figures did you have in your time?
No, it is amazing.
That doesn't speak to whether or not they are well paid. The fact that people, are rushing or they are interested in those positions doesn't speak to...
it shows that...
It might show something else. It might indicate something else. For instance, we know that in civil service, everybody knows how much. Well, maybe not everybody knows, but people have an idea.
Because of the high rate of unemployment.
Yeah, no, not the high rate of unemployment. People have an idea of just what the core civil servants earn, but people still want to work in civil service for a host of other reasons, not the pay.
What are the other reasons? Look, before I take up employment anywhere, I must have familiarized myself with conditions of justice in that sector. So I won't just get there now and start complaining.
Well, you haven't quite answered
okay,
Chamberlain's question of the number of people, or an average number of people that rush in, as you said, to become judges.
Yes.
We have an idea of the number of people that want to become president of Nigeria, even though the pay isn't there. But what are the numbers that you can give us? At what rate would you say that happens? The number of people that want to become judges.
You see, let me give you an instance. I won't give you the exact figure, but I can tell you that.
How do we then get the understanding?
I can tell you that for every single slot, you have over 20 lawyers competing to get that slot. For a single slot, you have at least 20.
Irrespective
competing.
of the level. Irrespective of
High
the
Court,
level.
State High Court, Federal High Court, Industrial Court.
Well, Mr. Osigwe seems to be disagreeing.
Yeah, but before he comes in,
Yes.
what other indicators are you using apart from the fact that lawyers are eager to want to become judges?
No, that's just to tell you that if, as you people are saying now, that the conditions of service are poor or too bad, then why the rush?
I think
Why the rush?
Okay.
I think that will not be taking a fair view of the situation by looking at the number of applicants. This job has to be done by somebody. And there are people who have a passion for something, and the fact that they go to do it does not suggest that they consider the pay good. Some people left well-paying jobs to become judges. But that does not detract from the fact that there is need to improve on the remuneration of judges. The Constitution says that the Revenue Mobilization and Allocation Committee shall make a proposal which shall be passed by the National Assembly for payment of their salaries. The last time this was done was 2007. Successive governments had made promises about doing this. Now, when you don't pay such persons who do a critical job like adjudication, settling disputes between people in a country like ours, indeed in any country, you don't pay them well, there's a danger that some untoward things may unwittingly creep into the system.
Such as?
Corruption. I mean, let's call it by bribery and corruption. Persons may be induced because they find themselves in situations where they cannot afford certain things. And by the nature of their job, they are not to do so many things like so many other public officers, and they are not to keep so many companies. While the Constitution has restricted what a judicial officer may do to farming, by the code of their conduct for judicial officers, they can't do so many things. They can keep certain companies, they can't attend certain things. So there is need to somehow insulate them and protect them by reviewing their pay and ensuring that it is such as to reduce the likelihood of any person being
Maybe I should
induced.
ask pointed questions. How much are they earning? Because you say that
yes.
they are not
You see,
as badly paid as people think.
They are not as badly paid. I also agree that there is need for review, just like other public servants. You see, the minimum wage used to be 18,000 naira for people in the public service or the civil service. Later, it was reviewed to 30, and now they are clamoring for 100. So, and it will go on and on like that. Let me say, judges' salaries are in two folds. The one from the NJC takes out their basic salary. Then the state.
How much is that?
The state, I don't have the actual figure now.
When you were in government, how much?
Let me come to that. Then the state takes out the allowances, housing, medical, factor allowance, rope allowance, donor allowance, and what have you. But let me go and understand. When I was there in 2011, the rent that we paid our judges in our state was 300,000 naira per month. And you pay that upfront, which is 3.6 million per year. But if a judge is living in government quarters, 20,000 will be deducted as the rent. Because you are living in government quarters, you'll be paid 280,000 naira as your rent allowance, 280,000 naira per month for 12 months, for a year. Look at my point. And the issue now is this. If there is any maintenance of that house, is also at the expense of the government takes of the maintenance of the house, of that quarters. Look at my point. So that's why I said it is not as that, it's not as bad as people are painting it. And again, once you are appointed as a judge, immediately upon being sworn in, when a judge has taken a sort of office, you get a key to your Prado Jeep. Or any other, yes.
That's a judge.
That's a judge.
And that's just a moment. And that's in Oyo State.
No.
And that's in Oyo State.
Is it in
right?
every state?
No, it is not.
That is in all. I'm just saying.
At the federal
I want
court
you to
too.
confirm.
At the federal court
I want
too.
you to
They
confirm
get-
that is in Oyo State.
In Oyo State.
And I think that our guest yesterday spoke from, talking about the judges, maybe not judges, magistrates, who administer.
Magistrates, their own conditions are just too bad. They are neglecting. Even judges are neglecting them. Just like judges are complaining that government is, they are neglecting magistrates.
Who's responsible for them when you were in government?
The state government.
The state government, judicial service commission, but the chief registrar, being the account officer, together with the chief judge, take care of their welfare. It's what they present to the state government at the same moment. But they don't even, it's like they don't reckon with them at all.
So with what you had, when you were in government, Mr. Sigwe, I'm coming back.
That's okay.
To you. With what you had as an AGF in Oyo State at the time, speaking to the issues which we are all aware of, which Mr. Sigwe just mentioned now, bribery and corruption, how vulnerable, what can you say that it put paid to instances of corruption and bribery when you were in government?
That's why I said we must not be theoretical. It's been theoretical. I'm talking from a practical perspective. I've been there, he has not. Get my point. Let me say this. Look, even if you have been paid billions, if you are a corrupt woman, be a corrupt person, you will still cut corners. Look at NNPC. NNPCs, they are well paid. They are the best. As far as, if you look at the CBN, well, look at the level of corruption there. It is alarming and crazy. So, paying judges this salary or not, look, when I got to practice in 1993, the judges that I met to grad them were given 504. Just 504. Later, he changed it for them to just 505. It was later that this is of Prado came in. And those judges, then, how much were they earning? And they were the best. You can't compare them to judges that we have today.
I think
you can't compare what their output, in fact, their character and everything. You can't compare to what we have today. So it's not about salary.
I think that's narrowing it down. The appointment process has increasingly got worse. So the caliber of persons being appointed to the bench may largely account for what he's alluding to. It's been politicized. Politicians have a greater say in who gets appointed, at least.
Don't they lobby to become judges?
Now, precisely my point. The appointment process does not reflect a merit-driven system. And so it would be wrong to use the old appointment process where people were appointed on. Sometimes, because of a person's performance, you will not even know the judges will refer you. And you may just say that you've been appointed a judge. Now people apply to judges, and a number of persons who apply for judges respectfully are persons who may have failed in practice, or who some politicians may have said, look, apply, who can get you there. It's a different kettle of fish. And when we are talking about remuneration of judicial officers, we always focus on the superior court, High Court, Court of Appeal, and Supreme Court. The entry point, the magistracy, the customary courts, like he said, the situation is appalling. In many states, there is no thought of ever giving them a vehicle. Some arrive in courts in Okada. Some take buses with the same persons that are trying.
Judges?
Magistrates.
They don't even have any official quarters.
We've seen magistrates protest.
Yes.
I think in Cross River, we saw magistrates protest.
And sometimes their salaries and allowances are withheld by government. And some of these persons find their way into the High Court. Imagine the kind of persons who will now join the Superior Court. I'm not suggesting that the moment to pay them well, the issue of bribery and corruption will go away. But first of all, let us pay them well. And then, if there's issue of bribery and corruption, then we can rightly say there's no justification. And I'm not saying that not paying well also is a justification for it. But reduce the likelihood of certain things happening.
But Mr.
Pay them well. So many judges, I understand, are not paid as well as some entry person.
Okay, because we're going to go there. Well, when he says that while he was there at the time, they received key to a brand new Prado Jeep.
We make you look as
your housing is taken care of.
That's such a big...
No, but the impression people have is that this was not even part of the deal. That's the impression some people have about.
I wanted to talk about some of the things he mentioned that the states are paying them may not be constitutional. Some states are doing that to augment what they get because their salary really is fixed at the national level through the NJC. So the point is, and some of these things are not uniform. State Governor A may do and State Governor B may not do. Some people are giving this Prado and for the next 8 years, they don't get any other car. And I'm coming. And then you also talk about this Prado as if you've done them such a great thing. Sometimes these heavy vehicles also take their toll on their salary because Most times the government gives you this and does not make any provision for the maintenance.
But they accepted it now.
Will you reject it?
Get it.
Will you not reject it?
Those cars
And they also
are
make
replaced
you
every 4 years.
Every 4 years.
In your state. I met some judges some weeks ago who told me that they are still driving the same cars they were given 8 years ago. And then some states are supposed to buy vehicles and show that they have them. And then when they are appointed, the vehicles are not given to them.
So when you say that we need to insulate the judiciary,
Yep.
what are the things that we need to do? I'm making that point advisedly because, first of all, is your theme, the theme of your conference,
That's
and then what
right.
Chamberlain also alluded to. If we are to insulate the judiciary, seeing that there are levels of authority and levels of judges. Levels of authority, I mean, there is a federal influence and then there is a state influence in their actions. And you may also take it to the customary and the magistracy and the rest of them. What do we need to do to insulate the judiciary, particularly judicial officers?
I think we need to look at judicial sector reform, which tackles the appointing process in the judiciary. I mean, it doesn't make sense to me that a state like this or unit judges, they first apply to NJC, which will approve the number of judges they have, then they initiate the process at their judicial service commission level, and then recommendations are made to Abuja, and persons who don't know the peculiarities of these people, don't know these individuals, pretend to conduct an interview, which from publicly available evidence does not involve more than a few questions being put to them, and then a decision is made, sometimes in not so clear manner as to whether it's merely driven, and then recommendations are made to the governor for appointment, you discipline them from here. We need to look at that. We need to also look at the composition of both the NJC and the JSC. I have always maintained that the process where the Chief Justice of Nigeria, and it has nothing to do with the particular individual who occupies the office, heads the Federal Judicial Service Commission, which makes recommendation for appointment into the federal court, moves over to the NJC and presides over recommendations he has made. So he's chairman here, he's chairman there. And then he's also chairman of the
That's
NJC.
against the principle of natural what?
Well, I wouldn't want to, it's an administrative thing. So, but you may also bring that into it. But the point is, and then if you look at the composition of the NJC, we need to do a whole lot of judicial sector reform, which will also reduce the involvement of politicians in the appointment process and have a merit-driven process where people write exams and also look, have a mindset change. In Nigeria today, just give me a moment and I'll round up. In Nigeria today, it's taken that for you to go to the Supreme Court, you must have gone to the Court of Appeal, even when the Constitution did not say so or does not say so. It is seen as an elevation. And I keep telling people, I sometimes talk about it as, we look at it like it's a Ibadan chieftaincy thing, where the oldest chief becomes Olubado. I don't know, I hope it's still the same. The most senior chief.
Not the oldest.
Because not the oldest, the most senior chief. And so he's thinking that he must have been a presiding justice, when the Constitution merely says he must be a person who has been a lawyer for, I think, 15 years post-call. And so it robs the Supreme Court and the Court of Appeal of legal practitioners who are in private practice, who are in the academia, and who are in the other fields in the legal profession who can contribute. And we complain about so many things. So it doesn't matter whether by the time you're being taken from Court of Appeal to the Supreme Court, you're very old and infirm, when you say, oh, from his zone he's the oldest, it is his turn to go. It's about turn. It is about, oh, how can you take his junior ahead of him? And I give an example, the Chief Justice of the United States, and don't tell me the US is different, was not even a justice of the Supreme Court, an associate justice, when he was appointed Chief Justice. And we must accept one fact. The appointment of a Chief Justice of a country is both a judicial appointment and a political appointment.
Which raises the issue you raised the other time. Let me ask do you agree with him? Just a minute. Do you agree with him, the issues about, insulating the judiciary?
Yes, I agree that we should isolate the judiciary.
How?
Yes. Like rightly said, the mode of appointment matters. In the time past, we don't apply to become judges. They don't. The judges on the bench and the senior lawyers will recommend you without your knowledge. They invite you. Look, I've seen the way you've comported yourself and you've handled your cases. Can't you join? We want you to come and join us on the bench. But we've done away with that. Now, we've thrown it open now. That what you need is at least 10 years at the bar. You may not even be in legal practice. You may not even be in active legal practice. You can be working in a bank if you're a lawyer. You can be, yes, it has happened.
So how do they expect to
then
get to
people who have never settled pleadings in their life have become judges. Who have they've never settled pleadings. And they're now judges. They're not on the bench. So how do you expect such a judge to be able to adjudicate in the best manner? Then also again, apart from that mode of appointment, that is very important. Knowledge, character, the two must coexist. And he talked about interference by politicians and other, which I don't agree with that as well. I don't. I was vice chairman of GSC 2011-2015, and we appointed 11 judges in 2 branches, 6 first, then 5 later. And I can say it, I've been my chair to say that my governor did not even have any input. He didn't call us.
Would you say others don't? Other governors don't?
Look, then is it the fault of governor? If members who are there, if you will turn it down, you will refuse. You tell him, we need to appoint the best.
Let's bring in Bookie.
Thank you, Chamberlain. It's interesting to listen to you, and the advocacy resounds, whether it's at the level of the judges or at the level of the NBA. Speaking of which, on our sister program just days ago, the NBA president disclosed that a Supreme Court judge's salary is somewhere in the realm of, this goes to you now, Mr. Osigwe, is somewhere in the realm of 700,000 naira, and this is miserly, considering the current economic realities. But the question is, what do you think would be enough that would insulate the judiciary from corruption and from the interference of politicians? Mr. Osigwe.
I agree that the 700,000 is a far cry from what a justice of the Supreme Court should get. But asking me to suggest what would be fair enough would be somewhat unfair to me. I'm not an economist, but a whole number of factors would have to be taken into consideration in determining that. And I think that's why the Revenue Mobilization and Allocation Committee has that responsibility. We have to look at the purchasing power of the Naira and a whole lot of other factors in determining that. So I would leave that to the right persons, but suffice it to say that we agree that the amount being paid it's pathetic and ought to be reviewed and increased. Many persons who have entry jobs in some organizations, I don't know how much they pay in CBN and all that, may actually be any more than these justices of the Supreme Court you have referred to. And we all agree that in the Nigeria of today, that shouldn't be. And if you even take it, that is less than $1,000, if I'm not mistaken. Less than $1,000. So imagine your justice of the Supreme Court being paid something in the neighborhood of maybe $800 or $900. And we agree that shouldn't be.
But Mr. Osigwe,
but I'm also not so... Yes, please.
If we agree without conceding that it's not enough, you have acknowledged that, the appointment of judicial officers, and that would be Supreme Court justices inclusive, is both a judicial and a political appointment. And if that is the case, do judicial officers have any reason whatsoever, to be influenced by both, politicians, and any other person who may want to influence, their decision or ruling on any matter? Do they have any excuse in the first place?
Now, by the oath of their office, it doesn't matter who appointed them or what interest that person may be, or what ideological viewpoint may have influenced their appointments. It is taken that once you're appointed, whatever affiliation we had with the appointing authority ends. And when I talk about being a political thing, it could be in countries like the US, where you have the Democratic Party appointed judges and the Republican appointed judges. So it's taken that the Republicans will appoint conservative judges whose views on certain issues are known, while Democrats will appoint persons who are liberals who will do certain things. That's the point I made about being political. In Nigeria, unfortunately, we don't have such things. And the FJC is there to ensure that it is somewhat politicized. But I believe that for heads of court, it could be a bit different. But that's a discussion for another day. And when we talk about insulation, I'm not suggesting that they need to be insulated from only politicians. They should be insulated from family members and even from co-judicial officers, because a head of court can interfere with the independence of a brother judge or justice. And other justices who are not the heads of court could also do that. So there is the personal independence and the institutional one, and a whole number of independence we're talking about. So insulating them means would entail appointing right persons who will have fidelity to their oath of office and not be influenced by facts other than the law, or the matters other than the facts and the law in determining cases. And cases, in assignment of cases, should be done in a transparent manner that do not also show judge shopping, forum shopping, or a deliberate assignment of case to a person whose views are known or who would decide in certain manners. So this conversation goes wider than suggesting that interference with their independence comes only from outside. It can come from within. It can come from the practitioners, lawyers who appear before these judges, or from family members.
Let me come to you now, Mr. Ojo. Former President Muhammadu Buhari had, signed some amendments that put the judiciary on the first-line charge, and one would have thought that that would sufficiently lay to rest some of the agitations from that arm of government, reminiscent of the time of strikes when judiciary workers went on strike. Putting the judiciary on the first-line charge financially, we wonder why that hasn't solved much of the problems of infrastructure within that arm of government. It's been some months after that. Why do we still hear stories about courtrooms, walls caving in on, judges while they're doing their jobs?
Thank you so much for that question. You see, we are isolating judiciary from the general problems we have in this country. It is Nigerian judiciary. Just like you have the rot in the agri sector, in the aviation, in the banking, we have that rot in the judiciary as well. So it is not only in the judiciary. I think that's our lot in this country. That the way we do our things, how do I put it now? It's like we are a different species of human beings. What does it take to improve the infrastructures in the judicial sector? What does it even take to improve or rehabilitate schools where our children are being educated? So we should not isolate the problem in the judiciary alone. But, let me say this now, we have a new Attorney General of the Federation, Prince Lateef Fagbemi. All of us, and I've not seen any exception, all of us in the justice sector, either from the bar or on the bench, all of us agree that the present government has gotten it right with that appointment. It's a fitting appointment. And we are expecting that with him in the saddle, things are going to improve tremendously. As far as the justice sector is concerned, things are going to improve.
Well, we hope so, Mr. Ojo, because reports suggest that there is...
I have no doubt about that.
The structure, reports suggest that the structure within the judiciary is such that there is always a court administrator in the court structure, so to speak, who handles every other matter apart from the legal matters that the lawyers and the judges are supposed to handle. If that administrator is not empowered to carry out, to execute infrastructure reforms within the judicial sector, isn't this suggestive of the fact that the leadership of the judiciary is also interested in executing infrastructure reforms within the judiciary rather than concentrating solely on legal matters?
Let me say this. Judiciary too needs to prioritize their needs. They should focus more on how to develop the system rather than going after frivolities. And let me give you an example. I think, was it about 4 years ago, justices of the Court of Appeal and Supreme Court were taken to Dubai for a seminar. The title of that seminar was how to take evidence. How to take evidence. Do they take evidence in the Court of Appeal and Supreme Court? Those training were meant to be for judges of the lower bench, those on the High Court. So they should also get it right. Look at my point. If they are judicious in the fund that are being allocated to them too, I believe things are going to be better, rather than expending what they have on frivolities and things that will not improve their lot or the system at all.
You're concerned that a lot of it is very important. I mean, the economy and the economic power of our judicial officers is very important. But that cannot be all that is, concerned with the rule of law.
Yep.
What other areas are you looking at to seeing? Because some people have also said that a lot of burden is also being placed on this new Attorney General. But he is the one who said that he intends to uphold the rule of law. So for him to actually live up to it, and for you to also agree that he's lived up to it, what other, indicators would you be looking at?
Thank you. You see, the problem in the judicial sector is systemic. And I will explain. We have High Court. For example, now, on your state, we have High Court. We have about 30 of them, 30 judges, many of our High Court. In the same Oyo State, we have Federal High Court, two judges there, making 32. We have Industrial Court there, 2 judges, making 34. Ogun State also has equal number, or if not more.
And so, I guess the numbers of the states.
Yes.
Okay?
So we are talking about 8 judges now, throwing out different judgments. But the appeal from all those courts, we come to one court of appeal. Look at my point. One court of appeal dealing with judgment from over 80 courts. You can see it is. Whereas we have one court of appeal, how will they handle and determine that? And people will be complaining there's delay in the process. Why would there be delay?
So you think he can do something in that regard?
He can do something. That is to say we need more court of appeals.
Do you think he can do it without touching the Constitution?
No. It's administrative.
Okay.
For example, now, in Oyo State now, the court of appeal that we have, they have 2 courtrooms. Only one has been used. Only one court.
So
why can't they have 2 panels? Or even more? Oh, and that means more judges must be appointed at every level of court. If we are the High Court, we need more. And they need also to create more divisions of court so that there will be access. When we were there, we used to have Ibadan division, Oyo, Ogbomoso, and Ibarapa. Just 4 of them. But you now expect somebody from Iseyin, which is about 1 hour to Oyo, to be taking his matters or dispute to Oyo. Then we said, look, let's also have a court in Iseyin that can take. We created more divisions, and we need more so that we can improve or expand access to justice, which is even better.
All right, Mr. Oshigwe.
I think I will take a different view.
Okay.
About having more divisions. It's not about more divisions. The region that used to be the Western region now has a Court of Appeal division in Lagos, in Ibadan, in Ado-Ekiti, in Akure, and Benin. That's 5. I think we should rather focus on the types of cases that get to the appellate court, especially the Supreme Court. Why would a tenancy matter that started in Iseyin, for example, in the magistrate court in Iseyin, find its way to the Supreme Court of Nigeria? Why would a chieftaincy matter in Iseyin that involves no constitutional law issue find its way to the Supreme Court in Nigeria? I think we should talk about that. Talking about what that Attorney General can do. I believe I read in the report that during his confirmation hearing at the Senate, he talked about looking into the propriety of having EFCC and having ICPC and some other agencies. I think that's a conversation we should be bold enough to sit down and have. And part of that conversation would also include, should the EFCC investigate and prosecute? Part of the judicial reforms I also think the Attorney General should look at the bail process we have in Nigeria. It has become extortionary, unless we don't want to tell ourselves the truth.
So it's not free as they say it is.
Why would a police station struggle to convince you that they're your friend and put up stickers that bail is free if it was not otherwise? We should look at a system that allows law enforcement agencies to simply pick you up, clamp you into detention, and start fishing for evidence. We should look at that section of Administration of Criminal Justice Act, which has now been incorporated in many of the Administration of Criminal Justice laws of the states, that allows the magistrate without any form of hearing to simply sign a detention order, which will be renewed without you being given a hearing to challenge the propriety of renewing it. We should challenge a system that seems to derive pleasure from depriving you of your personal liberty by putting you in detention to break you or to punish you. That does not make room for a judge to entertain bail hearing, either ex parte electronically, that has this long process of, my lord, we have just been served, we need 10 days to respond, well, the rule says this. Issues of personal liberty. We need to look at the propriety of judges continuing to impose ridiculous bail conditions on people.
What determines those conditions, though?
Well, the judges, they look at so many factors, and they simply say, and for example, one of the ways of ensuring that a bail granted you cannot be immediately enjoyed is to say you must have one of the shorties, but the person who has a property. Then you go through the administrative rigors of getting that property confirmed, and will be tied you if that property has no record at the land registry. And no law as yet in Nigeria says that all property must have a record at the land registry. We must look at a system that allows a judge to simply say, your shorty must be a civil servant, a PAMSEC. And this has thrown up a black market in the bail industry where civil servants who have never had any contact, who don't know the suspect.
Did you say bail industry?
Black market. Let's say the truth. There's a black market in the bail industry.
Is it that those bail
the bail conditions are imposed, and there are agents in court waiting for you once the judge has made that pronouncement to facilitate the provision of those persons for a fee.
What happens to the fee?
I've not collected this, I wouldn't know. But these individuals charge a fee, and they'll ask you, what is the offense with which you're charged? And then they will charge you based on that. So I would say that if we don't simplify these processes, it's a huge joke. It's a huge joke. And so many sections of our laws don't work. The Attorney General should, in my thinking, focus on policing, how policing is carried out in Nigeria. The abuse of enforcement agencies like the DSSS in getting detention order on the Terrorism Act, and even in charging people. It has become commonplace now for the police. Once there is any element of maybe any allegation of terrorism, it doesn't matter whether the facts are contained in proof of evidence, and the allegation comes from, say, Anambra, they will charge you to court in Abuja to punish you because that law says you can be charged anywhere. We must look at a whole lot of factors because our administration of criminal justice is such that people are losing confidence in it, and people are willing to pay anything to secure the freedom of their people without going to court. And it doesn't matter whether they know that they are innocent. That's why innocent or guilty. And family members are willing to pay anything just to get away from trouble. And that's why I say it has become extortionary. And we should focus on this because at the end of it is about perception. How does a person who is being taken to the police station feel? They feel apprehensive. They feel that they're in danger. They feel that they are in a very hostile environment where their life could be lost. And Nigeria is such a bad place that you can be taken to a police station. Nobody knows where you're taken to. Nobody is informed about the fact that you're there. Go to so many police stations. There are people who have been in their cells for years. And yet the Administration of Criminal Justice Act has provisions that such things should not happen. Magistrates should visit them. And there are reports of magistrates being refused entry into those cells.
Indeed.
And some even threatened with arrest. Who does that? Where does that happen?
Okay. Well, this, Mr. Ojo, you can comment on this one because, I mean, yes, the president did list his 8-point agenda, which included the rule of law. But even yesterday, while we spoke about this matter, partly the SAN did tell us that, look, he had persons who wanted to invest in the country, which is part of what the president also wants to boost the economy. And the part of the question was, how long does it take to get judgment or justice on a particular case, maybe at Appeal Court or Supreme Court? And when they heard that, when they heard it was really high, They left and went to another country. So yes, rule of law may be part of this agenda, but the economy also, yes, it means all of this are interwoven. Can we make any headway if we don't get it right at this level?
We cannot. And that's the truth. We must get it right. Because no serious investor want to come to any country where they know the educational process is nothing to write home about. And that's the present state of the judiciary in this country. Not of the justice sector in this country, because it takes quite a long, frustrating time to get your dispute resolved. Even our arbitration is not working. Because after the awards, you will still come back to court to enforce it, and you start another journey from there up to Supreme Court. That is not done anywhere in any seriousness other than in Nigeria. And that's why we said a lot of reforms need to be introduced by the present Attorney General, which they are. So he's capable. Mr. Lateef Fagbemi can do all of that. We must start even from the basic, like our judges writing long hands. Look, go to any state of assembly, any parliament, be it the state or at the national level. Look at them, you just see them as if they are playing or doing drama. But all their proceedings, immediately they finish, they get them. Because they have verbatim recorder in the parliament. If they have that in the legislative houses, why can't we have it? Must it be difficult? Why did it take judiciary so long a time to do all that? If they be able to do that in the parliament, that's why I said most of the blame we put at the doorstep of the government or of the executive. They are not made for them. If the judiciary tweet, they are part and parcel of their own problems.
How?
Look, okay, why is that difficult to do?
He's right.
Is it difficult? It's not difficult. Very simple, what do I call it? It's simple technology.
What needs to happen? Because I mean, Jimmy and I, recall how we went to court.
You just have to get it right.
Well, what is so difficult? Well, why is it so difficult to put such a simple technology in place?
Because let me tell you.
The request that they be switched off.
No, the reason is this. No,
yes.
No,
some judges have it and say if they don't trust that recording, they only trust their own recording.
Most of them are analog. And
some
again,
can't operate a computer.
They can't. Wow. So the problem is more complicated than what people see on the surface. Look, is that device is not something big. It's not a rocket science.
Do you think it should be a prerequisite that if you can't use technology, you shouldn't be a judge going forward?
I think so.
In this century, it must be.
Unfortunately, there's a pushback. There was and I'm not going to mention it, but I was told that one of the, I don't know whether to call it appointment process or recruitment process for judicial officers of a certain court in Nigeria. And the guideline was that there should be a computer-based test. And those who were seeking to appoint, they protested. Wow. And the debate was taken at the higher level of the body that would do the process. And they directed that process be cancelled, that a judge must not be compelled to be computer literate.
In this day and age?
Yes.
Yes. And it was cancelled.
Is that bad?
Wow.
Is that bad?
We are saying essentially that the road to justice reform is a very slow one.
And the system is resisting that.
It's a long way to it.
Which system is reducing it? The judicial system itself?
Yes. The judicial system itself. So
who would you recommend?
Says well, you have been judgment, they have 7 days.
Yeah, just a moment.
Sometimes it takes weeks.
Yeah, if you have been,
because they say my Lord is reviewing.
Just a moment, Mr. Sigwe.
He's going back for editing. You can't get a judgment. What the Supreme Court, U.S. Supreme Court, once a judgment is delivered,
it's online immediately.
It doesn't happen here.
It's online immediately.
One of the courts that has implemented it to the admiration of all lawyers is National Industrial Court. And I don't know why other courts find it difficult to imbibe that. Many courts launch with what they call e-filing. It's not an e-filing, it's an e-scanning.
Okay. Well, we need to wind down this. So let me ask both of you, if you were to advise the AGF, one key thing that he has to do almost immediately to probably kickstart, quote unquote, getting it right or getting the judiciary in good stead, what would it be?
We must do away with long and record of proceeding by judges. It must be totally done away with. It is archaic. In this age and
Can he make that law across board?
across board,
All
in all
of
levels of
everywhere.
court, all levels of court. And maybe for a start, they can start with the High Court. They can start with the High Court.
What do you think?
Well, I think any Attorney General, and I expect that from the current Prince Lateef Agbemeese and the current Attorney General of the Federation, to focus on justice sector reform that improves access to justice and focuses on enforcement of judgments. Rights are routinely being violated in Nigeria. Judgments obtained against security agencies that can never be enforced. And the Attorney General should pay attention to it because it is giving people less incentive to approach the courts where their rights are violated.
Okay. Wait, I see somebody wants to know what happens to the funds or the funds for the bill when they are paid?
They are not paid.
No,
I'm
they are
talking
not
about
paid.
a black market. It is those who participate to provide either surety or some other guarantees that make this one. So it's a business.
You don't get his question.
Which man?
When the court said you admitted to bail in the sum of,
yeah.
No,
you
it
don't
doesn't
pay
require any money. It's just a bond.
just a bond.
So you give
feed
the
that
bond.
that if this man should go away and you can't find
forfeit it to
you
the
forfeit
government.
it to the government. You go after this swati. The money is not paid.
All right, Mr. Debayo, Senior Advocate of Nigeria, former Attorney General and Commissioner for Justice for your state, and Afa Mosigwe, also a Senior Advocate of Nigeria. Thank you, gentlemen, for coming on today.
Thank you for having me.